Madam Chair, you may begin.
Thank you. Okay, good morning. The meeting of the Commission on State Mandates will come to order. Welcome to our hybrid meeting. For those participating in person, I do have some housekeeping information. On the table at the back of the room are paper copies of the meeting's notice, agenda, new filings, and witness list. The electronic public hearing binder is also located there on a laptop. Please note that the room is microphoned, so speakers and microphones on all devices must stay muted for the duration of the meeting to eliminate feedback noise. When called up for an item, the parties and witnesses will please come to the table and sit at a designated laptop. For those participating remotely, the materials for today's meeting, including the notice, agenda, new filings, and witness lists are all available on the Commission's website at www.csm.ca.gov under the Hearings tab. When being sworn in at the beginning of the hearing and when called for an item, the parties and witnesses will please turn on their video and unmute their microphone. At the conclusion of the item, please turn off the video and mute the microphone. In the event we experience technical difficulties or the meeting is bumped offline, we will restart and allow time for people to rejoin before recommencing the meeting. If we are unable to restart, a notice will be posted on the Commission's website listing the items to be heard at the next meeting. Please remember to speak slowly and accurately for the benefit of the court reporter and an accurate transcript of the hearing. Juliana, will you please call the roll?
Mr. Adams.
Here.
Ms. Gallegos. Ms. Gallegos?
Can you hear me here?
Yes.
Okay.
Ms. Green-Ross?
Here.
Mr. Polland?
Here.
Ms. Peralt?
Here.
Mr. Powell?
Here.
Madam Chair, we have a quorum.
All right. Thank you so much. We'll go ahead then and move on to item number 1. Are there any objections to or additional corrections of the June 12th, 2026 minutes? Okay. Seeing none, are there any public comments on this item?
Madam Chair, there are no public comments online or in the room.
Okay, seeing none, if there are no further questions from the members or further discussion, is there a motion to approve the minutes as presented?
I'll move.
Second.
Moved by Member Gallegos and seconded by Member Green-Ross. If we could please have a roll call.
Mr. Adams?
Aye.
Ms. Gallegos?
Aye.
Ms. Green-Ross?
Aye.
Mr. Polland?
Aye.
Ms. Peralt?
Aye.
Mr. Powell?
Okay, thank you. That motion carries. We will now go ahead and take up public comment for matters that are not on the agenda.
Please note that the Commission may not take action on items not on the agenda. However, it may schedule issues raised by the public for consideration at future meetings. We invite the public to comment on the matters that are on the agenda as they are taken up.
Thank you so much. With that, is there any public comment today on matters not on the agenda? Seeing none in the room.
Madam Chair, there are no public comments online.
Okay, hearing no public comment, we'll go ahead and move on to the next item, and I'll turn it back to Juliana.
There are no items on consent for this hearing. Let's move to the swearing in. The Department of Finance notified the Commission that they will not be participating in this hearing due to a conflict. Will the parties and witnesses for items 2, 3, and 4 participating remotely, please be sure that both your first and last names are listed on your Zoom window for the benefit of the court reporter. Turn on your video and unmute your microphone. And all parties and witnesses, please rise. Item 2. On behalf of the claimants, the City of Sacramento, the County of Santa Clara, and the County of Sutter participating remotely, please state your names for the record.
Michael Benner on behalf of the City of Sacramento.
Tara Fonseca on behalf of the County of Santa Clara.
District Attorney Jennifer Dupre on behalf of the County of Sutter in lieu of Jeffrey Greason.
Arthur Palkowitz on behalf of the claimants.
Thank you. Item 3. On behalf of the claimant, the County of Sacramento, participating remotely, please state your name for the record.
Mark Espesi, County of Sacramento.
Thank you. Item 4. On behalf of the claimant, the County of Los Angeles, participating remotely, please state your name for the record.
Howard Guest of Burhan and Guest on behalf of claimant County of Los Angeles.
And now, for the State Controller's Office, participating remotely, please state your names for the record.
Hi, Brett Haynes on behalf of the State Controller's Office.
Ken Howell, also on behalf of the State Controller's Office.
Thank you. Do you solemnly swear or affirm that the testimony which you are about to give is true and correct based on your personal knowledge, information, or belief?
Yes.
Yes,
I
I
do.
do.
Yes.
I do.
Yes, I do.
Thank you. We now ask the presenters for items 3 and 4, participating remotely, to please turn off their video and mute their microphones. Next is item 2. Chief Legal Counsel Camille Shelton will please present a proposed decision on race-blind charging 24 TC 07.
Good morning. This test claim addresses Penal Code Section 741, which requires county and city agencies that prosecute felonies and misdemeanors to develop and implement a process to perform an initial race-blind review and evaluation of a case before the prosecutor's ordinary evaluation for potential charging of a crime based on information that has been redacted to remove the direct means of identifying the race of the suspect, victim, or witness. The purpose of the test claim statute is to reduce the potential for unconscious bias in the criminal charging process. No comments were received on the draft proposed decision. Staff recommends that the Commission approve this test claim as specified in the proposed decision and authorize staff to make any technical and non-substantive changes to the decision following the hearing. Thank you.
Thank you. Parties and witnesses, please state your names for the record again. Mr. Palkowitz, Mr. Benner, Ms. Fonseca.
Good morning, Arthur Palkowitz on behalf of the claimants.
Michael Benner on behalf of the City of Sacramento.
Tara Fonseca on behalf of the County of Santa Clara.
Jennifer Dupre on behalf of the County of Sutter.
Thank you. Would any of the parties or witnesses would like to begin? And I'm not sure what order you'd like to take it in, but I'll leave it up to the 4 of you.
Okay, thank you. I would like to address this matter. First of all, I'd like to good morning to the Commission members and Commission staff. We had an opportunity to review the proposed decision. The claimants and myself agree with the conclusions of the Commission staff, and we would ask that the Commissioners approve the proposed decision. We're here to answer any questions you might have.
Thank you. Are there any others that would like to provide comment? Okay. All right. Seeing none.
I believe the witnesses are available to answer any questions that the Commissioners or Commission staff have.
Thank you, Mr. Palkowitz. I appreciate the clarification. Is there any public comment on this item?
Madam Chair, there are no public comments in the room or online.
Okay, thank you. Let me go ahead then and bring it back to the members. Are there any comments or questions from commissioners? Okay, seeing none. Without any further discussion, is there a motion to adopt staff recommendation?
I'll move.
I would second that.
Moved by Member Gallegos and seconded by Member Lee. If I could please have a roll call.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Green Ross.
Aye.
Mr. Polland.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
All right, that motion carries.
We now ask the presenters participating remotely for item 2 to please turn off their video and mute their microphones. Next is item 3. We now ask the presenters participating remotely for item 3 to please turn on their video and unmute their microphones. Chief Legal Counsel Camille Shelton will please present a proposed decision and parameters and guidelines on emergency shelters, persons with pets, 24 TC 06.
These proposed parameters and guidelines authorize reimbursement beginning January 1, 2024 for counties to provide public information about whether a cooling or warming center can accommodate persons with pets, and for cities and counties to post on their websites specified information for pet emergency preparedness. No substantive comments have been filed on these proposed parameters and guidelines. Staff recommends that the commission adopt the proposed decision and parameters and guidelines and authorize staff to make any technical, non-substantive changes to the decision and parameters and guidelines following the hearing. Thank you.
Thank you. Parties and witnesses, if you'd please state your names for the record.
Marcus Bessie on behalf of Sacramento County.
Thank you so much. Mr. Espesi, for the claimant, County of Sacramento, would you like to begin?
Yes, I was just here more for if there's any comments. I mean, we agree with the parameters and guidelines and we issue no comments, have no concerns. So just here if there's any questions.
Thank you. Appreciate you being available for questions. With that, is there any public comment on this item?
Madam Chair, there are no public comments in person or online.
All right. Thank you so much. Let me go ahead and bring this back to the members then. Are there any questions from the members on this item? Okay. Seeing none. Without further discussion, is there a motion to adopt staff recommendation? All right. Moved by Mr. Powell. Is there a second?
I would second.
Seconded by Mr. Adams. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Green Ross.
Aye.
Mr. Pollard.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
Thank you so much. That motion carries.
We now ask the presenters participating remotely for item 3 to please turn off their video and mute their microphones. Next is item 4. We now ask the presenters participating remotely for item 4 to please turn on their video and unmute their microphones. I note for the record that we have received 2 public comments that were filed after close of business yesterday. They were filed by interested persons, and we have, although it's not required, been able to serve those items and get them out for everyone. And with that, Commission Counsel Anna Barrich will please present a proposed decision on an incorrect reduction claim on child abduction and recovery 25-4237 I-05.
Good morning. This incorrect reduction claim addresses reductions made to the costs claimed by the County of Los Angeles for salaries and benefits to implement the Custody of Minors Child Abduction and Recovery Program during the audit period from July 1st, 2017 through June 30th, 2021. This program requires district attorneys' offices to actively assist in the resolution of child custody problems, including visitation disputes, the enforcement of child custody decrees, and of any other order of the court in a child custody proceeding. The controller found all of the claimant's costs totaling over $10 million over the audit period to be unallowable. Staff recommends that the commission approve the incorrect reduction claim for the following reasons. First, the controller's audit was untimely initiated with respect to fiscal year 2017-2018 reimbursement claim, as the controller initiated the audit more than 3 years after the claimant filed its claim, and since an appropriation was made for the program for that fiscal year, the audit period could not be told. Therefore, the audit for fiscal year 2017-2018 is void. In addition, the controller's finding that the claimant's source documentation in its entirety does not comply with the parameters and guidelines is incorrect as a matter of law and is arbitrary, capricious, and entirely lacking in evidentiary support. Although the controller has authority to audit the records to verify the actual amount of mandated costs, the courts have held that the controller's office is required to comply with the regulatory requirements of their parameters and guidelines when auditing for state mandated costs, and the interpretation of the documentation requirements in the parameters and guidelines is a question of law. Here, the controller found all costs unallowable, primarily because the county did not provide contemporaneous source documentation to support the mandated functions performed or the actual number of hours devoted to each function, and did not include a description of the specific activities or cases the employee worked on. However, the claimant provided contemporaneous source documents in the form of timesheets signed daily, which are expressly allowed by the parameters and guidelines as adequate source documentation with the descriptions and time spent on each reimbursable activity listed in the parameters and guidelines, and on time spent on activities that fell outside of the mandate. This complies with the parameters and guidelines requirements that source documents for salaries and benefits costs be identifiable to each reimbursable activity. No additional evidence is required by the parameters and guidelines to document the costs incurred. Thus, the controller's reduction for all costs on this basis is incorrect as a matter of law. However, the controller also found some of the claimant's individual timesheets had deficiencies, which the claimant did not dispute in this IRC, and that issue is not before the commission. The reimbursement claims should therefore be remanded back to the controller to reinstate those amounts incorrectly reduced on the grounds that all timesheets did not conform to the documentation requirements in the parameters and guidelines. Additionally, staff finds that the controller's assertion that costs related to good cause cases under Penal Code Section 278.7 are not reimbursable is incorrect as a matter of law. These costs are within the scope of the mandate and are eligible for reimbursement until the defendant first appears in court on a criminal charge. Staff recommends that the commission adopt this proposed decision approving this incorrect reduction claim and authorize staff to make any technical, non-substantive changes to the proposed decision following the hearing. Thank you.
Thank you. Would the parties and witnesses please state your name for the record?
Howard Guest of Burhan and Guest on behalf of claimant, County of Los Angeles.
Brett Haynes from the State Controller's Office on behalf of the State Controller's Office.
Ken Howell, State Controller's Office, Division of Audits.
Thank you. Mr. Guest, for the claimant, County of Los Angeles, would you like to begin?
Yes, thank you. Good morning, Chairman, Chairperson, and members of the Commission. As staff indicates, this is an incorrect reduction claim challenging the State Controller's disallowance in its entirety of reimbursement to the county for services mandated by the Custody of Minors Child Abduction and Recovery Program. There are 4 fiscal years at issue, the first 2017 through 2018, and then the next 3 subsequent years. The county supports the proposed decision and requests the commission to adopt it. The county is proud of the work that its district attorney's office and investigators did during this period. During the audit period, the county filed 141 cases. It declined 244 additional cases. It handled 112 Hague Convention matters. Its investigators opened 535 civil recovery cases. The DA's office and the investigators expended 67,328 hours on these matters, and this resulted in the recovery or reunification of over 300 minors. The State Controller's Office admits and concedes that mandated activities were performed. They don't dispute that. However, in their audit, they valued all of this work as 0. This was, as the proposed decision finds, arbitrary and capricious. In support of its work, the county submitted employee timesheets as well as other documentation. As noted, the parameters and guidelines specifically provide that employee timesheets are contemporaneous source documents. This program has been in place since 1979. The county has submitted claims every year. Since 1994, they've been using the same documentation, and every year the Controller's Office found the documentation to be sufficient and awarded costs up until the 2017-2018 audit period. Each timesheet is filled out by an employee on a daily basis. Each timesheet is certified by the employee as true and correct. Each timesheet is reviewed by a supervisor for accuracy. And as noted, Section 5 of the Parameters and Guidelines specifically provides that timesheets are acceptable. Each timesheet further divides the time between reimbursable and non-reimbursable time. Each timesheet further breaks down the reimbursable time into the 4 different categories that are set forth in the parameters and guidelines. As the proposed decision finds, these were contemporary source documents consistent with what the parameters and guidelines provides, and it was arbitrary and capricious for the controller's office to find otherwise. As the draft decision indicates, there were 2 other issues. The first issue was whether the audit for the 2018 fiscal year was timely. Government Code Section 1558.5 provides that an audit has to be initiated within 3 years of the filing of the claim. Here, the claim was filed on February 1st, 2019, but the audit was not initiated within 3 years. It was initiated on August 5th, 2022, more than 3 years after the date. And there is no exception that applies to this rule because there was an appropriation and there was reimbursement for the claim. So the statute on its face and its plain meaning clearly provides that it had to be initiated within 3 years. And in fact, in its comments on the proposed decision, the controller doesn't challenge this finding. Finally, there was, as noted, the issue of whether the county was entitled for what they call good cause matters or good cause reimbursement. Good cause is not a specific case. What it is when a parent reasonably determines that it has a good cause to keep custody of a child, even though they may not have the custody order, they can raise that as a defense. As the decision notes, this is covered by and has been covered in the past by the parameters and guidelines. This commission earlier this year in another child custody matter involving the County of Sacramento found that good cause matters were reimbursable, and that is similarly found and should be found here. As noted, there were a few questions as to whether some of the timesheets were properly filled out. We have no objection to addressing those issues on remand, although we will note that they're very minor, and as long as it's contained to that issue, we have no objection. Thank you very much.
Thank you, Mr. Guest. Mr. Haynes and Mr. Howell for the State Controller's Office, do you have any comments?
Yes, thank you very much. Thank you, commissioners. I know I stated before, my name is Brett Haynes, and on behalf of the State Controller, thank you for giving us the opportunity to address you today why we think, at least, that this proposed decision should not be adopted as it's currently drafted. We at least believe that there are certain ambiguities in the decision that may lead to abuse of the state mandated claims system in the future. We want to address some of those. As to the entire decision, the State Controller's Office generally stands by the written comments that it submitted. So I'm not going to be going over, the decision regarding the timeliness of the audit or the good cause decision. However, we did want to bring particular attention to some of the ambiguities in the decision, specifically in the conclusion and section C of the decision, which we think, in our view, need additional clarification in order to protect the state mandated system. Specifically, in the conclusion on bullet point 2, the conclusion that reads, the reimbursement claims are remanded back to the controller to reinstate those amounts incorrectly reduced on the grounds that all timesheets did not conform to the documentation requirements of the P&Gs. To us, it's not entirely clear what this recommendation, what it means. Is the commission explicitly recommending that we reimburse all of the requested amounts to LA on the basis that these timesheets as source documents and the timesheets alone are enough for reimbursement? Or is the commission stating that we need to reimburse LA County for the costs that were disallowable only because we did not initially view those timesheets to be source documents under the P&Gs, but where there is otherwise corroborating evidence? So essentially, to put it another way, is the timesheets alone enough? To the extent that the commission's decision is intended to be read as a single source evidence rule, where the timesheets in and of themselves are self-validating documents that in an audit do not need to be supported by any other evidence the state controller's office would be significantly concerned. We're concerned not about what we do when a record is shown to be inaccurate, but what we do when the accuracy of those documents just cannot be substantiated. Does this decision mean that a single source document alone is enough? Not only would that affect our ability to audit these in all mandated claims moving forward, but it would essentially mean that there's a decision that local entities would not actually need to perform the mandated activity, only that they produce a single qualifying source document stating that they did. Our purview of the audit is to make sure that the state mandated activity actually occurred, which is why we look, holistically at all the documents. With that in mind, local agencies can read this decision in a light most advantageous to maximize their recovery by either not keeping good records, because if the standard is if they can produce a source document that's qualified under the P&Gs and they have absolutely no records to support that documentation, but likewise in our audit, we cannot find any records that disprove that assertion, that would be enough. So for example, an invoice, and I'm sorry to use a absurd hypothetical, but an invoice could be a source document. An invoice, if we audit and the invoice is for the purchase of a 100-foot giant golden chicken, for instance, and I apologize for the absurd hypothetical, and we cannot find the chicken, we cannot see that anybody paid for it, we don't know where it is, but everyone says, oh, we bought it, and here's an invoice that's a qualifying source document. Are we therefore mandated to pay that mandated cost because a single source document exists absent other evidence? So for that reason, we think that additional clarification is needed to the scope and extent of this to prevent really a door being open to an abuse of the system. And I think that our audit manager, Ken Howell, can not only answer a lot of questions pertaining to this audit and audits regarding this mandated claim in general, but can speak to what he saw in the field regarding time records and the implications of this decision. I'm also happy to answer any questions, but I will pass it to Ken to sort of talk about what we saw in this audit, even if we consider the timesheets to be qualifying source documents, and what we see generally in these audits and why we typically look for additional substantiation.
Thank you, Brett. So I just want to highlight some of the additional reasons why additional substantiation should be required here. For instance, and I won't talk specifically about LA, I'll just talk about over the last 6 years of auditing, probably 14 or 15 different counties at this point. We've interviewed employees who've stated that they work on multiple different assignments throughout the year and aren't specifically assigned to just the child abduction recovery program. They might work on auto theft. They might work on a little bit of car. They might be pulled away for working on different assignments. But oftentimes when we pull the records, we actually look at the actual contemporaneous source documentation. It might show their time as being 100% to the car program. So a lot of times we go out and we interview people, we're getting contradictory information. So you've got a contemporaneous source document that may have all the required elements, but we're also getting contradictory information and we're not sure exactly how to treat that in light of this decision today. Since these are different timesheets, and I know other agencies have called them time studies, they don't often get the level of scrutiny that, say, the actual payroll documents receive. So a lot of times agencies or, again, individual interviews will say, oh, yeah, we were just told to fill these out, or we filled them out at the end of the month. I just looked back at my calendar. I just kind of put some time down. I wasn't really sure. I just kind of gave best guess sort of thing. Okay. So again, contradictory information. Can you really trust the numbers that are there? Is there any additional substantiation to validate the actual time that's on the time records? Calls that into question as well. Now, a lot of agencies don't have a formal standardized process for claiming time for reimbursement. Now, in the case of LA, they did. Those records obviously were consistent for the 4-year audit period. I won't address things back, beyond outside of the scope of our individual audit here, but at least for the 4 years, the records were relatively consistent in terms of the 4 major criteria. Obviously, the individual time increments for on a daily basis, and then for those certain individuals. We found some inconsistencies with the actual time records themselves, as Mr. Guest pointed out, but we did see those as well, which is very common for this particular program. Now, in the case of LA, I think one of the supervisors actually told us that when they actually review it, they review it to make sure that the vacation and sick time wasn't being claimed on the SB 90 forms, but they don't go back and validate any of the actual time that's being placed on for the individual days for the individual activities. They're just making sure that, say, vacation and sick time isn't being doubled up. Okay, so they're signing it, attesting that it's accurate, but they're not actually checking to make sure that it's accurate. But they're certainly signing it. Now, in the case of those individual agencies that don't have, say, separate line items that specifically exclude certain activities, which is after the person's first appearance in a court, say if it's all lumped together in one big pool, whether it be individual dates for, say, 168 hours for a month period, or it might just say car activities and no differentiation between the different types of activities. We don't know what's unallowable based on that. We don't have any sort of separate line item or anything to be able to further look at to determine, did they claim unallowable time after the first person's first appearance in California? We don't know. We just simply don't know that based on those records. So obviously the overall inconsistencies within the records call into question the overall accuracy of the records, which for us would then require additional level of substantiation or validation of those records. So historically, we've always pulled those time records and questioned costs that appear to be unsupported. And in terms of determining whether or not those costs are supported, we're going to be asking for additional information to say, okay, is 8 hours really 8 hours? Did you really work 100% on this program? What else do you have to be able to validate these costs? The way that this decision reads right now, we actually think it's kind of a major risk factor for potentially inflated claims in the future, because we all know every single agency is going to read this in the most advantageous way for them personally, which makes sense. Of course they would. We're just asking for more clarity on the commission's position related to the documentations themselves, and provide greater clarity not only for us as auditors, for the state controller's office collectively, but then also for the agencies too, in terms of the level of documentation that's required. Again, as Brett had mentioned, is it just the source doc alone? If it meets all the required elements, is that alone enough? Or are we allowed to find some? And if we find contradictory evidence, what do we do? So thank you. I'll be able to answer any questions you might have.
Thank you. Let me go ahead now and bring it back. I don't know if staff would like to make any comments in response to any of the parties and witnesses.
Yes, Anna, I'll take a first shot, and if you want to dovetail, feel free. First of all, this decision makes it very clear that we're not looking at all different audits that the controller has done. We purposely did not look at the audit reports that the claimant put into this record. There is an argument that the controller is using an underground regulation. This decision does not get into that. We do not make any findings on the other audits that you're performing. So this decision is limited just to the County of LA and the evidence in the record with respect to County of LA. A couple of things. One, this is the first time the commission has ever received an incorrect reduction claim when there has been contemporaneous source documentation on salary and benefits. We've never received this type of an incorrect reduction claim before. In typical cases, it's where a claimant will not even provide any kind of contemporaneous source documentation, and instead they estimate their time or provide a declaration way after the fact. And there has been some questions by the controller's office on the reliability of that type of documentation. This is the first time that this has occurred. And it does have a long history. The contemporaneous source document rule was put into the boilerplate language in 2010. Before it was put into the boilerplate language, it was the rule was litigated in Clovis Unified School District versus John Chung. In that case, they were alleging an underground reg, but that case is also important for a couple of other factors. One, it determined that the parameters and guidelines, which identify the source documents that are required for claiming, are regulatory in nature. They're binding on the parties. And so that has to be determined first. Two, the language in the P's and G's was proposed by the controller. The controller identified timesheets as reliable contemporaneous source documents on their own and indicated that claimants may provide additional documentation with respect to that. So under the parameters and guidelines, the claimant, when claiming salaries and benefits, has to provide contemporaneous source documentation showing the validity of the costs. The salaries and benefits have to be identifiable to each reimbursable activity identified in the P's and G's, and the claim has to identify the employee, show the classification of the employee, describe the mandated functions, which are the reimbursable activities performed, specify the actual number of hours devoted to each function, the productive hourly rate, and the related benefits. And when you look at these P's and G's, those are the only requirements for salaries and benefits. When they were claiming, if they are claiming costs for food and lodging and other materials and supplies for a child, then the P's and G's require an itemization of that. If they're claiming costs for foster care for a child, then the parameters and guidelines require them to identify the child when claiming. But there are no additional requirements for claiming salaries and benefits. That said, if the controller was reviewing these contemporaneous source documents that we have in this record here, which do identify the actual time spent on the reimbursable activities, and they're done on a daily basis. They're signed by the employee, and there's no reason to question the reliability of those timesheets unless the controller had interviews. I would agree, if the controller had interviews with the county staff and the staff said, well, I don't know if this is correct or not, or you had other information to question, that's within your audit authority. But the final audit report is not written that way. It is written as if all timesheets were not contemporaneous. They're all reduced to zero because no contemporaneous documents were prepared or filed. And that's the reason for the denial or the recommendation to approve the incorrect reduction claim here.
Can I ask you a question here? Is all of this a moot point because the audits was started too late anyway?
Only on the first year. So
Okay.
only the first year reimbursement claim is void because that audit was started too late. So we have valid jurisdiction of the 3 remaining years.
Thank you.
Thank you. Okay, I will go ahead and bring it back to the commission, but before I do that, let me just see if there's any general public comment on this item.
And Mr. Chairman, I'd like to respond to the controller's statements, if I may, for 2 or 3 minutes.
Very quickly, Mr. Guest, please.
Okay. The controller's office raises a hypothetical. Okay. They're not saying that what they're stating applies to this particular audit. As they say, they're worried about what happens in the future. So it's a hypothetical. I want it to be very clear that in the audit here, and I can read from their audit, they reviewed the annual mandated cost claims filed by the county. They complete an internal control questionnaire by interviewing key county staff employees. We reviewed time records. They were provided with case files and talked to employees. So this is not a situation, this case is not a situation that the controller's office is saying in the hypothetical. If they have a concern about future documentation, it can be brought up in future audits and addressed by the commission at that time. But that doesn't apply to this particular case. And they don't contend that it applies to this particular case. And I should note that they have ways of advising counties as to what kind of documentation they're required. They have a cost manual that people are supposed to address. They can advise people of what they might be looking for in that manual. They can always seek to amend the parameters and guidelines. But I just want to reiterate that their hypothetical does not apply to this case and should not interfere with the commission's adoption of the proposed decision. Thank you.
Thank you.
Madam Chair, can I just make clear, the recommendation here is to approve the incorrect reduction claim on the ground that they denied all in their entirety. On a remand, they certainly have audit authority to determine that individual timesheets are problematic and to not count those.
Yes, thank you. I appreciate the clarification. Let me just, I will go ahead, Mr. Haynes, in light of allowing Mr. Guest a rebuttal for 2 minutes. If you have additional comments that are quick, also under 2 minutes, I'll allow it. And then I do need to bring it back to the commission and public comment.
Yeah, and that's fine. And all comments taken, as they're stated, and I appreciate staff's additional clarification. So what I heard is on remand, just so we're clear, the state controller still has audit ability to substantiate the time, irrespective of LA, and they very well may and have submitted substantial documentation showing that they perform state mandated activities. Irrespective of that, we can review the timesheets to see if they're substantiated to make sure a mandated activity actually occurred, or are we, on this decision relegated to we add up the hours on the timesheet, we see if they match the amount of hours that's claimed, and that's enough. That's the clarity that we need.
Okay. The source documentation requirements are required by the P's and G's, which are regulatory. All they have to provide are the timesheets, which are contemporaneous, unless you have issues with that they're not contemporaneous, but from our view, they are. And they have to identify the reimbursable activities. They should be signed by the employee. That is enough under the parameters and guidelines for reimbursement. But the record indicates that there were some timesheets with problems. Some were not signed. I don't know what other problems existed, but there were individual problems with timesheets. Then that's certainly within your audit authority to determine whether those individual timesheets are reliable or not. We haven't seen them. But the argument on its face that everything is denied because all they provided were contemporaneous timesheets is not legally correct under these P's and G's. That's all they have to provide. If the controller wanted additional information, the controller can request that the commission amend the P's and G's.
All right, thank you. Okay. I appreciate the information from all sides. If I can go ahead now and bring it back, is there any general public comment either in the room or online on this item?
Madam Chair, there are no public comments in person or online.
Thank you so much. Let me go ahead now and bring it back to the commission. Are there comments or questions from members? Yes, Mr. Pollan.
All right, this is for the controller's office. If I understand your argument, it's that timesheets themselves are not sufficient evidence of services performed. Is that an accurate summary of your argument? Yes or no?
They may not be. They may not be.
Okay. What other evidence of services performed do you envision existing other than timesheets?
Well, it's whether the timesheets are substantiated with other evidence. So in circumstances where, let's say, for instance,
let me just get to the heart of it. What other evidence would exist that somebody performed work other than their contemporaneous record of having performed that work?
I'm sure, Ken, do you have examples of other audits you've done, what you've linked with timesheets to show the work?
Correct. Yeah, it would be, and I don't know if Camille mentioned this or not, but it was obviously addressed within the proposed decision. It's our proposed decision was the case files and case notes. So a lot of times agencies will say, well, if you've got these time records and we also have these case files and case notes, can we give those to you? Sure, we'll look at all of it, of course. But oftentimes the actual case files and the case notes don't have any sort of time increments associated with that or any sort of differentiation between, is 8 hours on your timesheet really 8 hours? Is it an hour? Is it a half hour? Did you even work that day? Were you off that day? We don't know. So if we looked at it again, if the agency gave us the case file or the case note, we would attempt to link the actual contemporaneous record to a case file or a case note and go, yeah, you did work that day. You worked 8 hours on that case. It certainly appears that you did. Great. So that would be some level of substantiation or validation to the actual accuracy of the actual time record itself. But again, as it stated in the proposed decision, there's no requirement that they give us those case files and case notes because it's not written into the parameters and guidelines. That's where the whole, you can amend the parameters and guidelines if you choose to at a future date. Doesn't apply to this particular IRC, could apply to future ones if in fact it's adopted. Those were the sorts of things that agencies would give us out in the field over the last 6 years that we would look at and try to somehow substantiate the actual time records themselves.
So then I glean from your response that you're questioning whether somebody honestly completed a timesheet. You said, I don't know if you actually worked 8 hours that day, although you claim to have. What types of professionals are the ones working on these cases? I'm assuming attorneys and law enforcement. Is that accurate or inaccurate?
For the most part, sometimes you'll get investigative assistants. You might get ADAs. Occasionally, you'll get a DA that will work on a case. That's usually if it's going to court. You might get some either some higher level investigators that might be going out and searching for missing children, things like that. It's typically those. Occasionally, you'll also get kind of more of a administrative individual that might also claim time for just record keeping purposes and things like that. But those are the typical individuals that would be claiming time for this program.
So don't those types of individuals have ethical obligations and duties of honesty that go with their professions?
Certainly, just as
absolutely,
as we all do, of course.
All right, no further questions.
Yes, Mr. Adams.
Thank you. I certainly understand both sides of this issue. It seems to me that I'm actually amazed that this has not come up before with P&Gs. So it just seems to me that this is a reminder for all that when those are approved, make sure what you want are in those P&Gs. And it seems to me that there's always a difference between trying to validate time versus the golden chicken that is bought. But it would seem to me whether it's a fixed asset item or time, I can appreciate the state wanting to be able to confirm and dig a little deeper than just the timesheet. But I guess this is a reminder to make sure how far you want to dig is in the P&Gs. Thanks.
Yes, thank you, Mr. Adams. Others? Yes, Mr. Powell.
So I have a question. Maybe this is because I haven't seen the timesheets themselves, but you say that a case record, a case note, in addition to a timesheet, may be sufficient. But my understanding, I briefly worked in DA's offices. A case note is just something you write in a file that you write at the time. It's not something that anybody verifies independently. And a timesheet is similarly something, because contemporaneously taken, is something you write on a file and is not independently verified at that time. And so I'm a little confused why a statement by a legal professional that has been approved by a higher ranking legal professional isn't sufficient. But if they had a writing on the back of a Redwell folder in addition to that timesheet, it would be sufficient. I'm a little confused why that becomes acceptable while a timesheet is not acceptable. I file a timesheet every month.
Sure.
And it's approved. I hope that it's not going to be rejected next month because I don't have a note.
Sure. Again, what we have seen out in the field is we have seen there's a wide variety of how agencies claim these reimbursement costs. Okay. So in the case of LA, and I think it was the last gentleman that spoke, it said, I'm kind of surprised this issue's never come before us. Yeah, same here. I'm surprised too. What we have seen is that agencies claim these things in a variety of ways. It might just be a gigantic general ledger dump where it's just a total dollar amount of $300,000. That's on their claim. There's no individual names. There's no individual time increments. There's no individual activities of the four main ones, nothing. We have a GL dump. Okay, that's one way of doing it. And then we have some that'll just claim a time record that'll just say CAR. Again, no additional activities, nothing else, and just a total amount of time at the end of the month, 168, 178, 176 hours, whatever. Okay, that's another way of doing it. You have LA. LA is a different way of doing it. County of Sacramento, they did it very differently too. So when we, as Brett had said, we attempt to look at this holistically based on interviews with individuals that were actually responsible for putting these things together at the time. Many times those individuals will say, and again, I'm not specifically mentioning LA, I'm saying in general, because obviously what is adopted here, people will take and kind of adopt it to the way that they're doing things in the future. We'll say things like, yeah, I kind of put this together just at the end of the month. I just kind of look back at my calendar. I wasn't doing it every day. I was just doing it by the month. Or the consultant told us to just put these together and we dated them on a certain date, but we weren't doing them every month. Okay, so when we get evidence like that, makes my brain kind of go, okay, so are these contemporaneous records? They're dated contemporaneously. They have all the required elements, but you're telling me that they're not. So there's always this conflict between what the P's and G's say and what's actually happening in the field and the information that we're receiving. And we're kind of caught in the middle trying to square adherence to the guidelines, but then also making sure that we're protecting taxpayer dollars and not paying out additional costs beyond those costs that actually are allowable per the guidelines. So there's always that push-pull in this process. And I know I've kind of rambled, but hopefully that kind of answers your question.
It sounds like to me, thank you.
Just to Mr. Powell, just to chime in, if you are interested in seeing an example of of the blank timesheets that they were using, I believe you can find it on pages 48 and 49 of Exhibit A in the record. It shows both sides of the page of the document. The individual reimbursable activities are referenced by code numbers, and then the back sheet explains which of those code numbers are associated with which of the reimbursable activities in the parameters and guidelines.
Thank you. Other comments or questions? Okay. I'll just say I again appreciate the comments from my fellow commissioners. I think really the question that is being brought forward is actually more focused on whether or not the current P&Gs require enough to validate the activities that are taking place. That being said, we have to function under what the current P&Gs are when making a decision about reimbursable activities in this case. And so, I think as was discussed or was noted by staff, if there is a question, and again, this was brought up by several of my other commissioners around needing additional verification in addition to the timesheets to, ensure their validity, then that needs to be illustrated in the P&Gs, and that would be something that needs to come back to be looked at to amend those. But I think the decision before us today has to be taken into consideration with the current P&Gs that are before us and what they require. So with that, let me ask just one more time if there's any other further discussion. Okay, seeing none and seeing no additional public comment, is there a motion to adopt staff recommendation or otherwise on this item?
Move to adopt.
Moved by Ms. Green Ross. Is there a second? Seconded by Mr. Powell. If I could please have a roll call.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Green Ross.
Aye.
Mr. Polland.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
Aye.
All right, that motion carries. So we will now go ahead and move on to our next item.
Next, Assistant Executive Director Dennis Supachana will please present item 5, salary adjustment, Executive Director, pursuant to Government Code Section 17530.
Good morning. At the Commission meeting on June 12, 2026, in closed session, the Commission members conducted an annual evaluation of the performance of Executive Director Juliana Murr. The Executive Director position has a salary range of $18,859 to $19,319 per month. Ms. Murr was appointed as Executive Director to the Commission on November 12, 2024, with a salary at the bottom of the range, and now she is eligible for a salary adjustment. The Commission may approve an increase of approximately 3% to the maximum salary of $19,319 effective on July 1st, 2026. If the Commission decides to adjust the Executive Director's salary, staff recommends this motion for a vote. I move to adjust the Executive Director's monthly salary to, please state an amount, effective July 1st, 2026, and direct staff to work with CalHR. Thank you.
Thank you. Are there any comments and questions from the public on this item?
Madam Chair, there are no public comments in person or online.
All right, thank you so much. Let me go ahead then and bring it back to the commission. Comments or questions from commissioners? Okay, seeing none, we do have a motion before us, and I'll go ahead and just read the motion one more time, which would be staff recommendation would be to move to adjust the executive director's monthly salary to $19,319 effective July 1st, 2026, and direct staff to work with Cal HR. Is there a motion to adopt the recommendation?
Madam Chair, I would so move.
Moved by Mr. Adams. Is there a second?
Second.
Seconded by Ms. Green Ross. If we could please have a roll call.
Mr. Adams,
Aye.
Ms. Gallegos.
Aye.
Ms. Green Ross,
Aye.
Mr. Polland,
Aye.
Ms. Peralt,
Aye.
Mr. Powell.
Aye.
All right, thank you so much. That motion carries. We'll go ahead now and move on to the next item.
Item 6, Assistant Executive Director Dennis Supachano will please present item 6, salary adjustment, attorney to the commission, chief legal counsel, CEA-B, pursuant to Government Code Section 17529.
Hello again. At the Commission meeting on June 12th, 2026, in closed session, the Commission members conducted an annual evaluation of the performance of Chief Legal Counsel Camille Shelton. The Chief Legal Counsel position was established at the CEA-B level. Ms. Shelton was appointed to her current position on December 9th, 2005. State policy authorizes the salary of CEA incumbents whose duties require membership in the State Bar of California to be increased above the applicable CEA range to a maximum of $19,046 per month. Ms. Shelton's current salary is $18,399 per month, which is below the maximum salary. The Commission may approve an increase of approximately 2.5% to the maximum salary of $19,046, effective on July 1st, 2026. If the Commission decides to adjust the Chief Legal Counsel's salary, staff recommends this motion for a vote. I move to adjust the Chief Legal Counsel's monthly salary to, please state an amount, effective July 1st, 2026, and direct staff to work with Cal HR. Thank you.
Thank you. Are there any public comments on this item from those in the room or online?
Madam Chair, there are no public comments in the room or online.
All right, let me bring it back to the members. Are there any comments or questions from members? Mr. Adams?
Just a comment, Madam Chair, as a member who's been sitting here for 9 years, I'm really pleased to see this, and I'll be proud to make the motion.
Thank you, Mr. Adams. Any other comments before we entertain a motion? Okay, and just as a reminder, the motion would be move to adjust the Chief Legal Counsel's monthly salary to $19,046 effective July 1st, 2026, and direct staff to work with Cal HR. So with that, I believe I have a motion from Mr. Adams. Is there a second?
Second.
Seconded by Ms. Green Ross. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Green Ross,
Aye.
Mr. Polland,
Aye.
Ms. Peralt,
Aye.
Mr. Powell.
Thank you. That motion carries, and we will now move on to item number 7.
Next, Program Analyst Jill McGee will please present item 7, the legislative update.
Good morning. The following are the legislative updates since the last time the Commission met. First, AB 2640, Commission on State Mandates, State Mandates. AB 2640 was introduced by Assembly Member Hadwick with co-authors Assembly Members Alanis and Ellis and Senators Niel and Ciarto. This bill amends Government Code Section 17558.6, which requires the controller to notify the claimant in writing within 30 days after issuance of a remittance advice of any adjustment to a claim for reimbursement that results from an audit or review. This bill would instead require the controller to notify the claimant in writing within 30 days of any adjustment that results from an audit or review. The bill would also allow a local agency or school district, upon receipt of the notice, to elect, at its discretion, to have the controller offset any reduced reimbursement as prescribed or to adjust the payment of claims. On June 17th, 2026, this bill was amended, passed as amended, and was re-referred to the Senate Appropriations Committee with recommendation to the consent calendar. On June 18th, 2026, this bill was read a second time, amended, and re-referred to the Senate Appropriations Committee. On June 29th, 2026, this bill was referred to the Senate Appropriations Committee suspense file. Next, SB 1439, Local Government Omnibus Bill. SB 1439 was introduced by the Senate Committee on Local Government. This bill amends Government Code Section 17560. Existing law, in the event that revised claiming instructions are issued by the controller between November 15 and February 15, provides a local agency or school district filing an annual reimbursement claim with 120 days following the issuance date of the revised instructions to file a claim. Among other things, this bill would instead apply that provision if the revised claiming instructions are issued by the controller between October 19 and February 15. On June 18th, 2026, this bill was amended, was read a second time and amended, and was re-referred to the Assembly Committee on Local Government. On July 2nd, 2026, this bill passed and was ordered to the consent calendar. On August 3rd, 2026, this bill was read a second time and ordered to the consent calendar, was removed on the motion of Assemblymember Carrillo, and ordered to a third reading. Next, AB 126, Education Finance, Education Omnibus Trailer Bill. AB 126 was introduced by the Assembly Committee on Budget on January 8th, 2025. This bill amends Government Code Section 17581.6. Among other things, this bill would add to the list of programs that are authorized for block grant funding in lieu of program-specific reimbursement to include requirements relating to the Menstrual Equity for All Act of 2021, Public School Restrooms, Menstrual Products, 22 TC 04. On July 9th, 2026, this bill was approved by the governor and chaptered by the Secretary of State. Finally, AB 395, Holidays. AB 395 was introduced by Assemblymember Gabriel. This bill amends Government Code Section 11131, the Bagley-Keene Open Meeting Act. Among other things, this bill would require that a state agency shall make good faith, reasonable efforts to avoid conducting any meeting, conference, or other function on a date for which the state agency knows or has reason to know that members of the public would be unable to participate or be present due to the ritual observance of a religious, cultural, or ancestral holiday. This bill would now authorize a person who has suffered harm as a result of a violation of certain of the above provisions to bring a civil action for injunctive relief as provided. On July 8th, 2026, this bill was amended, passed as amended, and re-referred to the Senate Committee on Appropriations with recommendation to the consent calendar, then was read a second time, amended, and re-referred to the Senate Appropriations Committee. On August 3rd, 2026, this bill was referred to the Senate Appropriation Committee's suspense file. Staff will continue to monitor legislation for bills that impact the mandates process. Thank you.
Thank you.
Thank you, Jill.
I have-
Next, legal.
I have a question, please, on that, Madam Chair.
Okay, that's fine. Did you want to do the question now, or did you want to do the question once we do items 7, 8, and 9?
No, I'd like to do it now. I'm just wondering if it's necessary for us to have these items read to us. We can read it, and the only updates were the last item that took place in the legislature, just as a matter of time. While I love to hear Jill's voice, I'm not sure that we actually just need the readout of everything.
I appreciate that, Member Gallegos, and we can certainly have a talk with staff around maybe trying to find a good middle point there. But I think part of it too is we're also reading it, but it's also an opportunity for us to make sure that the public is aware as well. So, but we can certainly have a conversation with staff about finding a balanced approach for both time and information.
That would be great. Or maybe even new information from last time, because these were also read to us at the last meeting.
Correct. We only read the updates since the last time the commission met and since the report was issued. Since our reports are issued during 2 weeks prior, we add anything to the script that isn't in the report.
Thank you. Thank you for the clarification. All right. We'll go ahead now and move it on to item 8.
Next, Chief Legal Counsel Camille Shelton will please present item 8, the Chief Legal Counsel report.
I do have something to report. The California attorneys, administrative law judges, and hearing officers in state employment, otherwise known as CASE, which is the union representing attorneys and hearing officers, has sued all state agencies. It's titled Case versus California Environmental Protection Agency. The commission was served on June 22nd. This case challenges state agencies' compliance with the governor's executive order N2225, which requires employees to return to office 4 days per week beginning July 1st, 2026. The allegation is that compliance and any policies adopted in compliance with that executive order violates the law on the ground that environmental reviews under CEQA are first required to be conducted. The commission was dismissed without prejudice on July 28th, 2026. I have no other litigation to report.
Thank you.
Thank you, Camille. And now the Executive Director's report. I have 4 information items for you. First, the office. Access to the office. On April 8th, the Commission lost access to its office due to a burst pipe and a fire in the office building. The Commission's office was not damaged. The building reopened and Commission staff returned to the office on June 22nd. The building will have a temporary electrical shutdown for additional repairs, which will necessitate the closure of the Commission's office from today, Friday, August 14, through Tuesday, August 18. Retirement. After 13 years of service to the Commission as Senior Legal Analyst, Carla Shelton will be retiring at the end of August. In addition to being the law librarian and doing her paralegal work, Carla has been the driving force behind the reorganization of the Commission's records. She's spent the last year setting the staff up for success in the future. While staff wishes her all the best in her retirement, her leadership and dedication will be missed. Carla, did you want to say a couple of words?
Yes. I want to say thank you. After 25 years of California State service, including 13 years at the Commission, I am retiring. I am grateful to my colleagues and managers for a rewarding career that allowed me to support my family and grow professionally. I look forward to a retirement focused on my health and family, and many blessings to you all. Thanks.
We're going to take a quick pause. I'm going to pause the Executive Director's report to be able to just ask for if there's any additional public comment on this specific announcement.
Hi, everyone. Kenny Louie, Chief Counsel, Department of Finance. I just want to say congratulations, congratulations, Carla. I've had the pleasure of working with you. Just want to congratulate you on your retirement, and happy to hear the news, and hope you the best.
Thank you. All right, we'll go ahead and now and turn it back to Juliana.
Thank you, Carla. I'm going to miss you. Okay, outreach. On July 29th, Camille Shelton and Jill McGee presented at a California State Association of Counties roundtable on the Commission's completeness review of test claims. The presentation resulted in a lot of great feedback and lasted considerably longer than the 20 minutes allotted as they fielded questions and demonstrated how to use the Commission's forms. On July 30th, Camille Shelton and Laura Doherty met with the state public defender and a member of her staff to explain the function of the Commission and state mandates. The information was well received, and we anticipate more opportunities to work with her office. This afternoon, Camille Shelton will be presenting an overview of mandates to the Department of Finance's staff. Budget. The Budget Act of 2026 includes the Commission's operating budget of $3.239 million and is broken down as $2.823 million for personal services and $436,000 for operating expenses and equipment, which includes a $20,000 one-time increase to cover rent for the current fiscal year. This is an increase of $48,000 from last fiscal year after adjustments for salaries and benefits. The Budget Act also included $90.607 million for local assistance or local agency mandated programs, a decrease of $3.496 million from last fiscal year. More details are available in the Executive Director's report. Workload. As of July 1, there are 36 pending test claims, 30 of which are regarding stormwater NPDES permits. In addition, there are 1 parameters and guidelines, 8 statewide cost estimates, 5 incorrect reduction claims, and 1 proposed parameters and guidelines amendment pending. Finally, tentative agenda items. This is a reminder to please check the tentative agenda items on the Executive Director's report or the pending caseload documents on the Commission's website, which are updated at least bi-monthly to see when something is tentatively set for hearing. Draft proposed decisions on all test claims and IRC matters are issued for review and comment at least 8 weeks prior to the hearing date, and a proposed decision approximately 2 weeks before the hearing. That's all I have, Madam Director.
Thank you so much. Let me go ahead and bring it back. I know we took the items 7, 8, 9 in a little bit of a bifurcated way this time, but are there any comments or questions from the public on either items 7, 8, or 9, additional public comments?
Madam Chair, there does not appear to be any additional comments from the public online or in person.
All right. Let me go ahead then and bring it back to the members. Are there additional comments, or are there comments from members on any of those 3 items? Okay, I'll just go ahead and add also my congratulations. I'm not sure if Carla's still online, but a congratulations to you in your retirement. You know, the Office of State Mandates is a small but very mighty team, and I know you will absolutely be missed. So wish you the best of luck. All right, with that, none of those items are action items. So we will now go ahead and move into closed session. The Commission will meet in closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. Commission will also confer on personnel matters pursuant to Government Code Section 11126A1, and we will reconvene in open session in approximately 10 minutes. Thank you. With and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. Commission also conferred on personnel matters pursuant to Government Code Section 11126A1. And with no further business to discuss, I will go ahead and entertain a motion to adjourn.
Madam Chair, so moved.
All right, so moved by Mr. Adams, and do I need to take a second on the adjournment?
I'll second it.
Seconded by Mr. Pollan. Do I need a roll call for that, or can I just adjourn? Yes. Roll call.
Mr. Adams.
Aye.
Ms. Gallegos did not rejoin us in open session. Ms. Green Ross.
Aye.
Mr. Polland.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
Okay. All right. With that, the motion carries and the meeting is adjourned. Thank you.